Ready, start. The order of a division bench of the Odisha High Court that is before us in this appeal, though passed in a judicial proceeding, appears to us to be completely alien to the law. The relevant fact to see the impugned order in perspective may be stated thus. Parachin, the respondent, and the appellant were married in accordance with the Hindu religious rites. About 3 years after the marriage, he filed a petition before the family court Raulkela for dissolution of his marriage with the appellant on ground of cruelty and desertion of the Hindu Marriage Act. The appellant strongly registered the ground taken by the respondent for dissolution of their marriage and took the plea that in reality she had been deserted and subjected to cruelty by the respondent. For the purpose of the present appeal, there is no need for us to go into the details of the allegations made by the respondent in his petition or the counter allegation made against him in the written statement filed by the appellant. Suffice it to note that on the basis of the evidence adduced before it, the family court in its judgment dated October 29, 2005 arrived at finding against the respondent on both the issue of desertion and cruelty, invoking, however, the provision of Section 23A of the Act. It directed the appellant to resume cohabitation with her husband, the respondent, within 3 months from the date of the judgment. The operative order of the family court as follows. Parachin, in the ultimate analysis, while rejecting the prayer of the petitioner seeking for grant of dissolution of his marriage with the respondent by the decree of divorce, I pass a decree of restitution of the conjugal life of the parties. Accordingly, the respondent wife is directed to restitute her conjugal life with the petitioner husband within 3 months. Hence, on the event of the respondent coming to the fold of the petitioner to restitute her conjugal life with the latter, he shall cooperate with the former, and that consequent upon success of the restitution of conjugal life between the parties, the impact gravity of the criminal proceeding 498A IPC started against the instance of the respondent shall be loosened paraching against the judgment and order passed by the family court. The respondent preferred appeal before the Calcutta High Court. The appeal was disposed of by a division bench of the High Court by order dated September 2, 2009. From that order, it appears that the respondent filed an affidavit before the court declaring his willingness to pay a sum of rupees 10 lakh only as life-term maintenance of the appellant and for the expenses of marriage of their daughter Kumari Ayushi Mohanty is consideration of the dissolution of his marriage with the appeal by a decree of divorce and compound of a criminal case instituted against him by the appellant, the respondent further stated in the affidavit that he would pay the sum of rupees 5 lakh only within 4 months from the date of passing of the decree of divorce, and the balance amount of rupees 5 lakh only in 4 equal installments separate over a period of 2 years from the date of the passing of the decree of divorce. The High Court, in its order dated September 2, 2009, simply paraphrased the statements made in the affidavit filed by the respondent and made it the order of the court. The order dated September 2, 2009 was modified by order dated November 20, 2009 to the further advantage of the respondent. It was clarified that the payment of rupees 10 lakhs only was not only for the lifetime maintenance of the appellant but also for the maintenance of the doctor Kumari Ayushi Mohanty till she got married, besides the expenses that might be incurred for her marriage. Stop.